All right. This is part 2 of the Court of Appeals denial today. In the one I was just doing, it was freezing up a whole lot, people were saying. So I'm trying to start a new one. Waiting to see if anybody gets on here to see that I'm even here. Okay, there's people here now. Before I continue where I left off on the other one, Buting tweeted again. So let me read his tweet. It says, the court said while CD showing Bobby's gruesome porn searches could show motive to kill Teresa Halbach, a direct connection of BD to crime was missing. But CT said new witness who saw BD pushing RAV4 might provide connection to make him another suspect. That can be raised in a new motion. Ugh, Sand says I'm still freezing. Well, I'm going to power through it because I'm on page 34 of 49. I don't know if it's just because we're getting a whole lot of people or I need a new computer or my internet sucks. And yes, it's bad news. It was denied. So let me post in this one too the link where you can read it for yourself. And I am on page 34 of 49. So I will just start in the top paragraph. So, and I have to leave in 45 minutes. So hopefully I'll get through this in that time. We do note that buried in the motion are two claims based on evidence that appears on the face of the claims to be newly discovered. According to Avery, in October 2017, his sister, Barb Toddock, who lived on the Avery property and whose son, Bobby Dassey, Avery identifies as an alternative suspect in the crime, told him two pieces of information that would impeach her son's testimony about last seeing Halbach walk toward Avery's trailer on the day of her disappearance. In Avery's view, his sister, quote, admitted that she knew that Halbach had left the property, unquote, on the day in question. This evidence, however, is equivocal and does not clearly the day of her death, or that any witness was aware of or lied about the fact at trial. Footnote says, the first piece of evidence is recorded statements in an October 2017 phone call between Avery and Barb Toddock and her husband, Scott Toddock. Avery identifies the full relevant portion of the transcript as follows. Stephen Avery, Bobby's home. Barb Toddock, he wasn't always home. Stephen Avery, well, most of the time he was home. People saying it's still really bad. I'm going to keep trying. Barb Toddock, no. Scott Toddock, he doesn't know fucking shit. Stephen Avery, and he said he left. She left. Scott Toddock, that's right. Back. Moreover, the evidence does not bolster any claim in the June 2017 motion, so as to warrant reconsideration of that motion. Even viewed on its own merits, the evidence does not entitle Avery to a Wisconsin statute 974.06 hearing because he has not shown that it is material. At best, we have two unsworn statements by Barb Toddock that Dassey told her something that is potentially inconsistent with his trial testimony. This is hearsay that would be inadmissible at a new trial, meaning that it cannot constitute newly discovered evidence as a matter of law. Avery chose to frame these claims in the context of a motion to reconsider, but without applying that legal standard, or in the alternative, explaining why he had a, quote, sufficient reason for not bringing the claims in previous motions pursuant to Escalano Naranjo. Tweeted again. Let me read it. Yeah, we're supposed to get storms here. He retweeted Kathleen Zellner's tweet, which I will just read again. Not deterred by the appellate court decision, it pointed out the specific doors that are still open for Mr. Avery's quest for freedom. We appreciate the careful reviews. #onward, #truthwins. And then Buting said, the court opinion shows a path for Stephen Avery's freedom. Zellner Law will pursue that path and others to seek justice. Okay. Here of more of that phone conversation on the bottom of this page. So, okay. Barb Toddock. Yeah, she left. Stephen Avery. Yeah. Barb Toddock. Yeah. Stephen Avery. Well, he didn't testify for that. Barb Toddock. The second piece of evidence is an October 2017 posting on Barb Toddock's Facebook page. Avery identifies the full relevant portion of the posting as follows. Oh, hold on. Okay, good. If you're watching me, person who just texted me, I'll get back to you when I can. Okay. The second piece of evidence is of the posting as follows. Barb Toddock. Well, I have your answer for all of you that was wondering. Just got off the phone with Bobby and I asked him and he told me that he seen her, and then it says in brackets, presumably Halbach, pull in, but that was it because he left to go hunting then. He said that is the truth. And then it has in brackets, commenter or Facebook friend. So he never seen her walk toward Stephen home? Barb Toddock. No. All right. So then, as discussed in the section above on the June 2017 motion, we are willing to give Avery the benefit of the doubt, where possible, as to why he did not raise certain claims in 2013 or on direct appeal. But we cannot ignore the law, and thus we cannot simply determine whether the merits of his motion to reconsider claims warrant an evidentiary hearing, where the only narrow question before us is whether the circuit court erroneously exercised its discretion in not reconsidering the June 2017 motion on the basis of purported new evidence obtained within those claims. And that footnote says, although the merits of these claims are not properly before us, we have reviewed them in our broader review of this appeal. We note that the evidentiary basis for some of these claims is lacking. For example, one claim is based on Avery's assertion that Ryan Hilgas, Halbach's ex-boyfriend, later possessed a day planner that was in her car on the day of her death. The evidence Avery submits, however, does not and cannot reasonably be construed to support this conclusion. Moreover, other claims do not appear on their face to entitle Avery to a hearing. For example, one claim, as far as we can tell, is based on a recreation of what Halbach's movements would have been had she driven away from Avery's property on the date of her death. From this experiment, which is unsupported by any explanation as to how Avery might prove the underlying hypothetical scenario, that Halbach did in fact leave, Avery seeks to implicate Bobby Dassey and Scott Taddock, his brother-in-law, in Halbach's murder. End of the footnote. We conclude that the Circuit Court did not erroneously exercise its discretion in denying this motion. The court noted that Avery provided no explanation for filing the June 2017 motion while, quote, considerable investigation was still being conducted by the defense, unquote. Knowing that not all the facts were, ready for presentation to the court, and with no deadline for filing his motion set by the court or statute, the defendant proceeded to file the motion prematurely, The motion was pending before this court for a few months before the court issued its ruling. During that period, the defendant did not ask the court to stay its ruling pending the conclusion of testing, request time to supplement the motion, or take any other action requesting that the court delay its final decision in this matter. The motion was submitted to this court, and the court ruled on the motion. Now we go on to page 37 of 49. Christopher, can you, if you're asking for what I'm reading, there's that link. Motion number 4, July 2018 supplemental motion. Avery appealed from the Circuit Court's October 2017 and November 2017 orders denying his June 2017 motion and his motions to vacate and reconsider respectively. In May 2018, Avery moved this court directly, quote, to supplement the record on appeal with a CD disclosed to defendant for the first time on April 17, 2018, unquote. Avery asserted that supplementation of the appellate record was appropriate because the contents of the CD related to claims already presented to the Circuit Court. We stated that this assertion, quote, misses the point, which is that we are not a fact-finding court and cannot consider items not presented to the Circuit Court, unquote. We determined, however, quote, based on the assertion that Avery recently received previously withheld discovery or other new information, we retain jurisdiction but remand his case to enable Avery to file an appropriate supplemental post-conviction motion to the Circuit Court, within 30 days of the date of this order. The Circuit Court shall hold proceedings on the supplemental post-conviction motion within 60 days after the motion is filed, unquote. In July 2018, Avery filed his motion to supplement the July 2018 motion, alleging a Brady violation. And the footnote for that is the state points out that a motion already decided, i.e. the June 2017 motion, cannot be supplemented, and that there excessive motion. Regardless, this court has determined and ordered that the July 2018 motion, as well as the subsequent March 2019 motion, or motion number 5, shall be treated as a supplement to the June 2017 motion. End of footnote. Recall that prior to trial, Avery unsuccessfully moved to introduce third-party liability evidence pursuant to Denny. He alleges that the state withheld significant evidence both favorable to his Denny motion and relevant for impeachment purposes. A final investigative report of Detective Mike Velli, I don't know how you say that, saved on a CD, the Velli CD. Velli created the report through forensic examination of the hard drive of a computer used by Dassey, Bobby Dassey, let's get that straight, whom Avery identifies as a possible Denny suspect. The Veli CD contains thousands of images of violent pornography that Avery argues, quote, reveal a propensity for sexual violence, unquote, by Dassey, Bobby Dassey. I want to make sure people know that it's Bobby Dassey. Avery elsewhere attempts to explain why, of several people who use the computer, only Bobby Dassey could have downloaded these images. The CD also contains a timeline that purportedly, quote, impeaches Dassey's trial testimony, unquote, and, quote, criteria, word searches, registry, recovered pornography, internet history, Windows registry, and all MSN messages, unquote. According to Avery, he did not receive the Veli CD until April 2018. The circuit court determined that there was no Brady violation because there was no evidence suppressed. Footnote for that says, as this claim was to be treated as a supplemental motion pursuant to this court's order, Avery was not required to allege a sufficient reason under Escalona Naranjo for not raising the claim in his June 2017 motion. We assume, without deciding, that Avery had a sufficient reason for not raising this claim in his 2013 motion or on direct appeal based of the evidence. End of that footnote. It is undisputed that the computer was examined and its contents copied to 7 DVDs. It is undisputed that Avery's counsel received these 7 DVDs prior to trial. Finally, it is undisputed that, with limited and irrelevant exception, footnote, Veli attests the only information on the CD titled Dassey Computer Final Report Investigative Copy that is not contained in the 7 DVDs would be okay. But it looks like, because a lot of times she retweets the same thing. Okay, it's the same one. The only information, okay, I already read that part. And techniques routinely used by a digital forensic examiner during a forensic examination of digital evidence. End of footnote. The Veli CD does not contain any additional information than what is on the 7 DVDs. Consequently, the Veli CD is not suppressed evidence, but merely an investigative summary of evidence provided to Avery. Avery appears to acknowledge these facts on appeal, but argues that he should have had access to information derived from Veli's, quote, unique word searches, unquote, pornographic images refined for relevancy. And material suppressed evidence, and Avery has presented no authority extending the principle to the prosecution's withholding of secondary compilations or analysis of such. Brady, quote, Brady applies only to facts that are not already known to the defendant. The government need not facilitate the compilation of exculpatory material that with some industry, defense counsel, marshal on their own, unquote. Avery's computer expert attests that Avery did not really analyze the computer, but does not conclude that Veli CD contains additional information not provided to Avery. In my opinion, based upon a reasonable degree of certainty in the field of computer forensic science, the CD contains information and files extracted from the 7 DVDs that, in Detective Veely's opinion, were relevant to the investigation of Ms. Halbach's murder. While the information contained on the CDs is derived from the forensic image contained across the DVDs, trial counsel trial defense counsel was not provided critical information, including the criteria used by Detective Veely in performing his forensic computer examination, as well as the results of that examination. Page 40 of 49. We're in the home stretch. Avery raises two related arguments concerning the disclosure of the DVDs themselves. He argues that the state deliberately misled him about the importance of the DVDs by stating in an email that they, quote, did not include much of evidentiary value, unquote. Even if the statement mischaracterized the evidence, however, an off-the-cuff description of disclosed evidence cannot form the basis for a Brady violation. Avery further argues that he was only provided the DVDs approximately 1 month before his Denny hearing, leaving him to introduce relevant evidence in that proceeding. But this argument properly concerns alleged ineffective assistance of trial counsel, see below, because such conclusory statements did not adequately explain why trial counsel could not have analyzed the DVDs in time for the motion hearing, sought to postpone the hearing, or taken any number of other steps to effectively leverage this evidence. In the July 2018 motion, Avery does indeed argue that trial counsel was ineffective for failing to forensically examine the 7 DVDs prior to trial. He does not summarily, however, and in a manner that leaves us unable to meaningfully analyze this claim. Regarding potential use of this evidence in this Denny motion, Avery does not address the prejudice prong of the Strickland test, which in our view encompasses at least 2 key inquiries. To admit evidence at trial that Dassey could have killed Halbach, Avery would have to provide some evidence at the pretrial Denny hearing directly connecting Dassey to the crime. Evidence that another party committed the crime may be admissible pursuant to Denny if the defendant can show 1. the third party's motive, 2. the third party's opportunity to commit the crime, and 3. some evidence directly connecting the third party to the crime. That Dassey possibly possessed violent pornographic images might have conceivably satisfied a separate requirement, motive, but is insufficient in and of itself to allow admission of third-party liability evidence. That footnote says, Carrie is saying the feed has been breaking up since page 25. We are hearing only a few words. I have 8 pages to go. I'm still going to keep going. Hope I don't know what else to do. I don't know what's going on with Facebook or my computer. So I apologize for how crappy this is. In more ways than one. Okay, where was I? Although only, I'm on a footnote, although only tangentially relevant to our decision, we note that Avery's counsel misrepresented some key facts underlying this claim in the motion to the circuit court and briefing to this court. Avery asserts that only Dassey could have downloaded the images, created folders containing photographs of Halbach, and, quote, searched for key terms relevant to the murder, unquote. He states that Dassey, quote, was the only individual at home, unquote, when this computer activity took place, but references for support only the affidavit of his computer expert, who does not and cannot opine on Dassey's schedule, and a sheriff's department interview with Dassey containing none of this information. Avery also characterizes the pornographic images as, quote, bearing a striking resemblance to Halbach and to the nature of the crime committed against her, unquote. support for this conclusion in the evidence on record. That Avery misrepresented the facts is immaterial to deciding his Brady and ineffectiveness claims. We point them out because of the high profile nature of this case, the greater possibility that interested members of the public will read the briefing and motions, and the resulting need where misrepresentations are particularly egregious to note where Avery's arguments wholly stray from the facts. End of that footnote. Avery failed to meet the direct connection requirement in his original Denny motion and has not presented additional evidence on this point in motion number 4. Thus, even assuming trial counsel was deficient in not analyzing the DVDs, Avery cannot demonstrate a reasonable probability of a different outcome at the Denny hearing or at trial. And that footnote says, as discussed below, we are not addressing Avery's most recent filing to this court. See our discussion on motion number 6, which seeks to directly connect Dassey to Halbach's murder. If Avery wishes to raise that claim, he will need to bring a new Wisconsin statute motion. That motion would need to survive both Escalona-Naranjo scrutiny and be found to have merit, in which case the evidence presented might supply the missing direct connection. In that event, the Veely CD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such 974.06 motion, and all such issues would be for the circuit court to decide in the first instance. And a footnote back up to where it was. Impeachment purposes, even accepting that the CD contains, quote, a timeline that impeaches Dassey's trial testimony, unquote. We are skeptical at this point. See note 25. Avery does not explain how impeaching Dassey about the use of the computer would have changed the outcome of the trial. At most, the jury would have disbelieved Dassey's testimony that on the day Halbach last visited the Avery property, he saw Halbach walk towards Avery's trailer. He did not see her leave the property. Halbach's RAV4 was in the driveway when he left to go hunting, and the RAV4 was gone when he returned several hours later. Avery identifies these as the key pieces of testimony. Certainly, this testimony bolstered the state's theory that Halbach visited Avery on that day and did not leave the Avery property thereafter. But absent this testimony, the state still possessed significant forensic and other evidence implicating Avery in a crime committed on his property, without any showing or argument as to why the impeachment of Dassey would have undermined the cumulative effect of the other evidence. We cannot conclude that the trial's outcome would have been different. We conclude that the circuit court did not err in denying the July 2018 motion without a hearing. Motion number 5. March 2019 supplemental motion. In January 2019, Avery again moved this court directly to stay the appeal and remand for the circuit court's consideration of specific claims relating to the state's 2011 release of Halbach's family of suspected human bone fragments. We determined that, quote, given the specific circumstances of this case, unquote, we would stay the appeal and remand pursuant to Wisconsin statute 808.075 for action on this issue. We again ordered remand to the circuit court to permit Avery to pursue a supplemental post-conviction motion on specific claims, and we directed the court to conduct any necessary proceedings. The circuit court denied that motion without a hearing. The gist of motion number 5 is that the state released to Halbach's family suspected human bone fragments recovered from the Manitowoc County gravel pit, thereby violating 1. a circuit court order, 2. Wisconsin statute 968.205, requiring the state to preserve certain biological material evidence connected to a criminal conviction, And 3, Avery's constitutional rights. As a Wisconsin Statute 974.06 motion may raise only jurisdictional, constitutional, and like claims, we consider only the third argument. Avery alleges that in 2011, bone fragments from the gravel pit, which Avery wished to test to determine if they contained Halbach's DNA, and might thereby indicate that Halbach was not killed on Avery's property. Avery argues that, quote, the state, by its actions in returning the bones, ... has implicitly admitted that the bones were not only human, but that they belonged to Ms. Halbach, unquote. Avery frames this as a violation of Arizona versus Youngblood, under which a defendant's due process rights are violated where the state either 1, fails to preserve, acts in bad faith by failing to present potentially exculpatory evidence. Avery represents that he was not aware and could not reasonably have been aware of the release of the bones until after he filed his 4th motion. We will assume, therefore, that this claim is not procedurally barred under Escalona Naranjo. The state argues that Youngblood analysis only properly applies to the destruction of pretrial evidence. We agree generally,